Good morning and good afternoon. My name is Kathleen Regan, and I'd like to welcome you all to a LexisNexis complimentary webinar titled Starting Your Own Firm, Understanding Client Relations and Fees. Before introducing our speakers, we have a few announcements. Today's program is not eligible for CLE credit. For our phone participants only, if a problem arises during the program, please dial *0 for the operator. We will be using the hashtag @LexisSmallLaw to have a conversation on Twitter during today's program if you are interested in joining us. Please take note of the survey that is available to you. We ask that you please complete it as it provides excellent feedback for us so we may continue to bring you outstanding programs that meet your needs. Our panelists today welcome your questions. You may submit your questions via the Q&A section of the platform during our program today. Our speakers will try to address as many audience questions as possible. Please keep in mind all questions may not be answered due to time constraints and that no questions will be asked verbally. And now I'd like to introduce our speakers. Joel Hand is an accomplished trial attorney. In 19 years of practice, he has tried in excess of 90 jury trials and 200 bench trials. Patrick Johansen, CLM, CPP, is the Director of Business Development at Brinks, Gilson & Leone. He has spent a decade in law firms leading business development and marketing departments. We thank Joel and Patrick for their time in preparing today's webinar. Gentlemen, the floor is yours.
Good afternoon, and thank you for joining us for the webinar. Again, my name is Joel Hand, and I will be one of your presenters today.
And I'm Patrick Johansen, and I will be the other, and I'll be kicking this off. Today, Joel and I want to cover 3 areas with you. I'll be taking the lead on the first 2 agenda items, briefly introducing the way lawyers do marketing and business development, and then talking about this new thing called law firm pricing and the latest thinking around fee arrangements.
And I'll take the lead on the last 2 agenda items, sharing my thoughts and experiences on client relations at the end of this presentation. We also want to leave you with a checklist of the many factors to consider when starting your own practice. Patrick will go ahead and get us started.
To begin, if you'd please take a moment and let us know where you're at on your journey. Have you started your own law office yet? As you do that, I want to just give you the little framework that we want to make sure to talk to the majority of the group and ensure that what we're talking about is meeting your expectations. And expectations is going to be one of our key themes as we get into client relations. So about half of you have answered so far. We'll wait for it to get just a little higher. The plurality of you started over a year ago, with more than a quarter thinking about starting your own firm at 65%. 70%. Okay. Okay, so there we go. So with 71%, we're going to move on here and say, yes, we've got more that have been doing this for a year, so we'll try to keep the basics to a minimum for you, but those of you who are right there behind trying to start their own firm, we want to make sure we cover that for you as well. So as we move into the first section, I want to introduce briefly the concept of client acquisition for those of you thinking about your own firm. Even though today's presentation is focused on current clients, it is important that you understand the process of how to get clients and, more importantly, how the expectations you create in that process affect your client relations and client retention. The relationship journey is just that. It's a journey. It's a cycle. There have been many folks to create sort of interesting, colorful graphical representations. This is one that I have used in some way, shape, or form over the last 20 years to really help you understand how marketing works in a very basic level for all of us. As consumers, we know there is a process to how we make a purchase. And one of the things I want to emphasize as we go through this, just because you're a lawyer and you walk into a law firm, do not take your consumer hat off. That is one of the biggest detriments I have found in working with law firms over the last 12 years, is that we think there's something unique about the purchase of legal services. And to some extent there is, because it's a business-to-business type of arrangement rather than a business-to-consumer relationship for the larger firms at least, but even for the smaller firms. And that's very different than, how, say, Procter & Gamble does its marketing. So people think it's different, but in reality it's still this same journey. There still has to be an awareness in the marketplace by your prospect that you exist, that there is a lawyer here in my backyard or in my practice need. From there, you move on to interest and consideration. Now that I've sort of narrowed this large field, we're going to talk a lot about cars for whatever reason. Maybe Joel and I like cars a lot, which actually we do. We're both Camaro buffs. That's a different story. You have to know that there's this world of automobiles, and then you have to understand that there are domestics and foreigns, and then you have to figure out where you fall in the good, better, best type of arrangement in the GM scheme. Are you a Chevy, a Buick, or a Cadillac? And that is in part based on price point, but in part it's also based on brand loyalty and so on. We'll get into those concepts. So once I start narrowing it down, then I start considering which of these that I like. That first part is called marketing. That broad general awareness of the marketplace, what you're doing to make sure that people know you're there and kind of what you can offer. That's called marketing. As you move in that consideration process with your prospect, and as you get to the notion of evaluation and selection that you've made, maybe a second call back from a prospective client, or maybe a coffee with them to find out more about you. Now you've moved into the area of sales and business development. We don't like to use sales word too often. So business development. So you can see the overlap of marketing and business development, and you can see where sometimes there's confusion. What's the difference? We want to make sure that you do understand that. At that point, once you get to selection, the client says, I'll sign your engagement letter. Let's do this. Now you've moved into the realm of client service, which is going to be the bulk of our presentation. And that's where we can focus on client retention, focus on client cross-selling, upselling, referrals, which of course leads to evangelization. I like this lawyer. I like Joel. He's a great lawyer. He helped me. Let me tell you about him and my friends in my group. That's the journey, and as you can see, how you do your marketing in the front end can have an effect on what your clients think about you and your service on the back end. In terms of those relationship activities, therefore, there are two basic types of relationship building activities, marketing and business development. Marketing is known as one-to-many, as we mentioned in that sort of scale. It's advertising, it's networking, it's social media, it's websites, it's whatever you do on your end to communicate to this broad area to make sure people are aware of you and to give people reasons to consider you and add them to their short list. Business development, on the other hand, is what's known as one-to-one. This is where you, as the product, are talking directly to the prospect. Here I am, here's who I am, what I can do. Let me hear from you what you need, and let's see if we can create a space for us to work together. Also during this activity, we may have initial fee discussions. As we mentioned before, are you in the market for a Cadillac or a Chevy? Part of that is based upon what's my budget. How much do I want to pay for not only how much do I have to pay for a car, I might be able to qualify to buy a Cadillac, but maybe I only want to buy a Buick. I don't see the need to spend $50,000 on a vehicle. I think $30,000 is sufficient. That in part will drive those fee discussions. That's not getting to the engagements part where you say, okay, here's me as a client, what I will pay you, whether it's an hourly rate or a contingency or whatever, we'll get to that. But it's just this, am I in the ballpark with you in terms of what I think my legal needs should cost? Also in this area, as you heard me talk about all those in dialogue and discussion, what we're really saying is it's all about communication. It's really all about that key of being able to figure out who you are and what services you have and what your value is, and being able to communicate that to either broad markets or individual one-on-one prospects. For those of you who are considering personal law, whether divorce, personal injuries, estates and wills, maybe DUIs, that's more of a business-to-consumer type of model where you're speaking directly to individuals, and that B2C is going to have a different flavor than for those of you considering, say, more of a business corporate law firm where you're going to be working for entities, business entities. Then you're going to operate under what's known as a B2B type of marketing model. So when you hear us talk about B2C or B2B, that will help you sort of understand where we're going in terms of who we're speaking to. So for key communication there, for instance, we're talking about all this communication. When you're doing your marketing, you really want to consider what your brand is. We've all heard about branding as consumers. So what is your brand as a lawyer, whether it's an individual or as someone in a 2 or 3 partner firm? You have your own brand, and so does your firm. It may be the same like Joel. And then what is it? Be deliberate about creating that and then communicating that, selling that to your marketplace and to your prospects. PR, are you writing? Are you speaking? Are you taking requests from reporters? Are you letting them know that you're available to talk in those key areas? All of that external communication is called public relations. How are you doing in that category? And be thinking about that as you put your plan together, something Joel will mention at the end. And social media, of course, we've all been inundated with social media. So take part. It's free. It's fairly easy. It helps you do that one-to-many communication flow. On the business development side, you really want to focus on, for now at least, 2 areas. Number 1, what's your elevator pitch? What is that 30-second description of who you are and what you offer that makes you distinct from other lawyers and makes someone want to say, tell me more? That's the elevator pitch. Second is that value proposition that I mentioned before. What is your value proposition? These are unique statements talking about your benefits that no other lawyer or very few lawyers are able to say to a market or to an individual client. Those value propositions, and I use that word deliberately because if you go and Google value propositions, you'll be able to find lots of great resources and tools and a better understanding that we can't tackle here about why VPs become so important in business development communication. And then finally, when you're talking about fee discussions, you want to be real clear before you get into those, what your hourly rate is and what that means and what that covers. And are you comfortable with the contingency? And if so, what that is and how you're going to structure that. We're going to talk a little bit about fees structures in a minute here. But those 3 areas each have their own set of key communication areas for you to be aware of. So we want to take another brief poll here, and that is, LexisNexis offers pricing promotion for select new firms with up to 75% off legal research pricing. Would you be interested? Okay, we're about halfway there. Thank you for that. We'll just give it another minute for you to be able to have a follow-up after today's webinar on LexisNexis services. Okay, we're at that magical 71% again. Okay. So, moving on to the next area, law firm pricing. The pricing discipline has basically 3 broad areas. If you've ever heard of the analogy of the 3-legged stool, well, it applies here in pricing, in this economic discipline that you may have briefly touched upon in high school economics or a college course. Price helps you do one of 3 things, which is so important when you're first starting your practice or even as you're continuing it in its early stages. Number 1, it helps with positioning. Are you a $100 an hour lawyer or are you a $500 an hour lawyer? That makes a big difference, and that sends a message about who you think you are, in a good way, not a bad way, what you think your brand is, where you think you stand in the marketplace. Positioning is very important when it comes to pricing. Too often everyone is just sort of keeping up with the Joneses. Okay, I hear these folks over here are charging $275, so that's what I'm going to do. It's fine to do that, but realize that you may be leaving money on the table if you don't put your price at where it matches your true value to your clients. Second, price helps prospects decide if they're going to hire you. Think about all of us when we walk into a store. If we're on every grocery shelf, there are half a dozen products, all with slightly different prices, whether it's $2.99 or $2.89 or $2.79 or $3.49. Does that matter? It does. And so pricing is important to help people purchase. That's why for the last 7 years since the Great Recession, one of the things has been, can I have a discount? You hear a lot about Big Law giving 10% discounts, giving 20% discounts because of purchasing. They want to have those clients keep purchasing. Very important. And finally, and obviously most importantly to all of us, pricing helps with profitability. If you decide you're going to be a $100 an hour lawyer, but then all of your overhead costs, you need to be a $320 an hour lawyer, guess what? You're not going to be in business very long. So the 3 Ps of pricing are real important for you to know, not only in just this abstract notion that, yeah, there are these things you have to think about, but in very real, tangible ways of how they affect how you can practice law. So one of the critical aspects of pricing is the price tag. As I said with the grocery store, what's the price of milk today? Okay, well, the local one is $3.29 and the one from the generic one is $2.99. Okay, I think I'm going to go with the cheaper one. What is the price tag? That which we call hourly rates. In order to know that, one of the things to help is competitive intelligence. If you don't know what your competitors are charging, or even what they're doing, not only what they're charging, but what services they may be offering, you may be missing the boat on certain services, or if they're offering very basic level wills and you're coming in at a more sophisticated trust level, then you could be charging more for that service because it has a broader appeal and it has greater value. So are you pricing correctly? You need to know what the market rate for your services is in your jurisdiction. Very important. If you don't have local resources to figure that out, there are a few general benchmarks that are published annually. For example, here is the 2014 ALM Survey of Law Firm Economics. And for 2014, you can see the average partner price tag is approximately $350 an hour.
So as Patrick said, knowing and understanding your competitive pricing for your market and for your practice area is truly of critical importance. I know when I first started in a new practice area for my own firm, I wanted to be able to price myself in my services below much of my competition so that I could attract more clients and build my practice. Honestly, it was my desire to be viewed as more of a dependable Buick or Acura rather than a Mercedes or Lexus, to help differentiate myself from the large firms and already well-established boutique firms in this particular practice area in my region. However, as I positioned myself in this particular practice area, I found that I was putting myself at a much lower price point and unintentionally devaluing myself too far below the quality of the product and the results that I was able to produce for my clients. So by positioning yourself too low in this scale, you can cause a client to feel more inclined to question your work and your effectiveness, regardless of what your results may be. Likewise, the pricing must work for both parties. You have to know what your clients can afford and what their expectations are. Even if you have a client who believes in you and wants you as their attorney, the client must be able to afford your services for the attorney-client relationship to work. Clients who want to buy a new Mercedes but can only afford a 10-year-old Ford or some other cheaper type of attorney or vehicle in our example case are clearly not going to be a good match. But what about those clients who appear positioned to be able to afford your Buick-type services, but ultimately would have been better suited with Chevrolet? Doing your due diligence to ensure that clients can truly afford your pricing is also critical. Collecting outstanding client legal fees can become extraordinarily costly, and not just in terms of your out-of-pocket expenses to hire a law firm to do the collection agencies, filing fees to pursue that through small claims court or otherwise. But in addition to all of that, you have to keep in mind that by going out and collecting fees against former clients, it can do some damage to your reputation in the community. And it's certainly not going to engender that former client to say anything positive about you within the community and even to other prospective clients as they may come into contact with them. So that brings us to a discussion of value.
Once you can get your arms around price, the next step is to understand that the purchase price is a proxy for, in part, it's communicating value. Because ultimately, we as consumers and our clients seeking legal services are all about value and all about getting the most for our money. So what is value? As I hope you can see on slide 12, value is a relative concept rooted in the worth of your service to a client as measured by the maximum amount a client is willing to pay for your service. Let's break this apart. You see the 4 red words there. Relative. Value is not black and white. Your services are not black and white in the marketplace. They're always relative. They always have a different value to the purchaser. As we mentioned earlier, someone may want to buy a Mercedes but can only afford a Ford. Where do you fall? Because conversely, maybe they think you're a Ford and they're looking for a Mercedes for representation, especially if it's, you know, a DUI or some other sort of personal issue that has life ramifications. It's relative. You have to understand that even though you have a price tag, you need to be flexible when dealing with individual clients. Next, worth. This is rooted in your worth. Again, you're standing in the shoes of your clients. How do they perceive your services, your reputation, your brand? That all ties into your value. Maximum. As clients have in their minds a certain budget, and even if they don't know how much, say, a divorce is going to cost, they have this little mechanism, psychological issue that says, well, I don't think it should cost more than, you know, $15,000. And whether they got that from their next door neighbor or they got that from looking at their amortization charts that they're going to do for how much they're going to make over the next 12 months, you don't know. But they have a maximum. And the ideal pricing theory is for you to get the maximum dollar from the client for your services. And then finally, willing to pay. Willingness to pay is a key theory in the economic world that we don't talk about much in law firms. But clients have a certain willingness to pay. We all have to when we are consumers. So back to the vehicle thing. You know, maybe we can afford the, you know, all-wheel drive luxury version of that car, but we really only want to pay for the base model. If you understand where your client's willingness to pay, what their motivation is, that will help you to know to bring out those value propositions to say, you know, if you're only willing to pay this much, do you think that the service I'm going to provide is only going to be that? Or if I can prove to you that I'm going to provide more value for a service, wouldn't you agree that the budget ought to be more? So be thinking about that. McKinsey offers a nice definition of value revolving around the trade-offs between the benefits and the price. This is going to help us get to our equation here in a minute. But we all are always making a trade-off whenever we spend money, whenever we purchase. And so the issue is, what's the value in that dollar spent? We're hopefully getting more than 100%. And that's where you want to try and persuade your prospects and your clients that you are, in fact, worth more than what you're asking them to pay for your services. Finally, a great book that came out a few years ago, Value Merchants. You have to persuasively demonstrate and document the value you provide to your customers. That is the key, because there's this whole world out there, we so far have alluded to them as competitors, called next best alternatives, a pricing term. Next best alternatives. Who else are your prospects talking to? Who else could your prospects go hire? That's what you need to know as you think about what your brand is, what your pricing is, what your offer is going to be, how you package your value propositions to go talk to the marketplace. So you can wrap those two up in a nice, neat little formula. V equals B minus C. Value equals benefits minus costs. You know what the cost is to the client, at least in terms of your legal fees. There may be other costs involved that you don't know, maybe travel to your area, the emotional distress of whatever they might be going through. But then you need to quantify those benefits, both for yourself and for the client, and then also ask the client what they believe those benefits are. That's where you're going to know you're winning the value equation. And if you're winning the value equation, you're going to be successful. So, now that we've gone through pricing, we've gone through value, let's take a quick look at what we all know, which are the type of fee arrangements. A quick history first. Prior to the 20th century, attorneys at law didn't operate on this crazy system called the billable hour. Crazy meaning it causes lots of people to talk, not necessarily that it's good or bad. You know, way back when, it was all about bartering. You know, it was largely about flat fees. It was about it wasn't the economic driver that it is today. We have the American Bar Association to thank for that. Post-World War II, the ABA noticed that other professionals, doctors, accountants, were earning better livings than a lot of the attorneys in the United States. After doing a search and having a task force, they decided that the billable hour, first introduced in 1920 at Hale and Dorr by a former Harvard professor, saw that that was a great way to capture actual work and capture the most profit. So the ABA started selling the idea of lawyers doing billable hours. So it's only been a 60-year concept, so to speak. And it worked, right? At least till the Great Recession. And so as a result of that, for the last several years, AFAs, alternative fee arrangements, some people call them appropriate fee arrangements, because hourly billing can be a fee arrangement, and according to the continuum of fee arrangements, it is one. So these appropriate fee arrangements have been around for a long time, and clients have started to push back on them with the big law firms, and so they slowly trickle down. I mean, small law firms see them almost every day because clients need help but can't necessarily pay standard hourly rates. So this chart helps you understand what I consider to be the 16 most common fee arrangements and how they work together, how they interact on this continuum. Organized, 16 of them organized into 4 buckets: time-based, budget-based, performance-based, value-based. This will help you as you go to market, so to speak, when you're working with prospects, trying to figure, okay, if you're really after what's your motivation, what's your driver? If you're after a budget, then let's look at a capped fee perhaps, or let's look at a fixed fee, or even we'll do a phase fee. A fuller description is available on my blog if you want to take a look at that, but that's sort of the genesis of, excuse me, where we're at with fee arrangements. So we'll take a quick poll here. Which fee arrangement do your clients request most often? It would be helpful for us to know that as we move forward in the poll presentation. We're about halfway there, and fixed fee is winning by quite a lot. Hourly rate's a close second. Contingency a distant third. We do have someone who has clients asking for value-based fees. My guess would be that that attorney is doing a really good job with his or her value propositions and being able to describe to clients why it is the rest of the market is sort of missing the boat when it comes to how law services can be provided. Oh, we've stuck at 40% here. All right, we'll give it just another 10 seconds to see if anyone else wants to jump in here and tell us about, of course, well, then again, that would make sense because if the plurality of you are not opened your firm yet, you wouldn't have clients to answer this question. So, okay, so we're going to go with 40% there and weave that into the rest of our presentation.
Okay. So let's talk then a little bit about fees. Knowing and understanding the competitive fee structure for your particular market area, as well as your practice area, is clearly of critical importance, as Patrick has talked about. I know when I was first starting in my private practice, I found, like many of you probably have or will as well, that when I first opened the door, clients didn't just start streaming in to hire me. As a result, I ended up taking some cases that were somewhat outside of my prior experience areas. Foolishly, I did not first investigate the market for pricing and fee types in these other areas prior to taking on such clients. As a result, I took on some family law matters for a ridiculously low flat fee. Since I came from mostly a criminal law background where 90+% of the work, at least in my area, is done on a flat fee basis or a fixed fee basis, my market, at least in my marketplace, this became my expectation for other business-to-consumer type relationships. I could not have been more wrong. What I quickly came to realize is that even the most simple and straightforward family law matters, hours invested can multiply at an alarming rate due to personality conflicts between the litigants, which may or may not have been previously known. Suffice it to say that long before at least one of those such cases was resolved, I ended up earning only pennies on the hour rather than dollars per hour. I can guarantee you that's a mistake I will not make again. So even before you have the fee discussions with your client, you need to put some significant thought into the types of fee arrangements you're willing to make. What is commonplace within your local or regional market for those practice areas? How do your closest competitors' fee arrangements compare with yours? And what could you do to make yours better or more attractive to clients? In my local marketplace, we see predominantly hourly rate fee structures for the business-to-business type client relationships, while on the personal business or business-to-consumer relationships, we see primarily contingency fees or flat fee structures. However, I would, as a word of caution, just remind everyone that you need to be very cognizant of your rules of professional conduct or lawyer ethics, which may restrict or prohibit the use of certain types of fee structures in certain cases. For example, in Indiana, where I practice, it's actually unethical for a criminal lawyer to take on a criminal case on a contingency basis. And there are also a very high number of attorney discipline cases that are somehow related to legal fees that are charged. So you need to make sure you're taking those attorney discipline cases into consideration when you're setting your fees, your fee structures, and even selecting your fee types. Now we want to move on and talk a little bit more specifically about client relations. And first, we're going to open that up with a poll.
So as we jump into client service, let's get a sense of people's attitudes about great client service. We'll ask you to choose one of these 10. Off to a slow start here. Looks like people are taking time to think about all of these. Kind of challenges your brain halfway through our presentation here. Want to make sure you're still awake and engaged, and client relations is going to be a big part of this second half. So let's see what you are thinking. All right, we've passed the magical 71%. Exciting. We'll see if we can hit 80. Hovering at 79%. And there's 80. 81, okay. 81% of you say keep clients informed is just behind, oh, let me make sure I get the understanding the client's issues. There we go. Okay, full slide. Well, in some way, this is a bit of a setup, as you might guess, because these are sort of very specific types of options. These, in fact, come directly from an annual survey of client service conducted by the BTI group. The poll answers are actually the top 10 attributes that large firm and mid-sized firm clients say are important to them when evaluating their outside counsel. And in fact, the top 10 are arranged in descending order, so that the number one skill according to BTI, or number one attribute according to BTI, is legal skill, which falls way down our list here today. In fact, number 7, understand the client's issue, comes out number 1 for our group. And keep clients informed is, in fact, the number 4 answer from BTI. So great. So this gets you thinking and trying to figure out, okay, let's talk now about how these all play out. So here is the actual BTI results. I don't see the chart. Apologize for that little error. Okay, so each year BTI Consulting Group surveys in-house counsel on a myriad of factors designed to measure their satisfaction with outside counsel. BTI has identified 17 drivers of client satisfaction. 17, seen on this graph. If you read from right to left, you'll see that the horizontal scale is what's important to clients. So the number 1 that shows up at the far right is legal skills. Unfortunately, as you see, the vertical axis is the ability for lawyers to differentiate, or law firms to differentiate themselves and their service to their clients. So I say unfortunately because legal skills falls below that axis and therefore is not really easily differentiatable, which seems to make sense, right? Let's hope all lawyers have at least a basic level of legal skill. And even wherever that client needs a lawyer to be, there should be a market, it should be a competitive group of individuals who all have that same level of legal skill. So yes, it's critically important, but no, it's not necessarily something that clients are going to look at and say, I'm going to make that my one criterion of decision. No. In fact, it falls in what's called the price of admission, that quadrant that you sort of need in order to be considered for hire. Because what we really want is that upper corner, superior financial reward. Before we get there, sorry. So number 1, skills. Number 2, committed to help. Number 3 is quality. 4 is communication, and 5 is value. But let's take a look at those top 5. So in the upper right-hand corner, that superior financial reward quadrant, we've got 2 of the top 5 drivers there. Commitment to help and provides value for the dollar. So now remember, this quadrant is characterized by high importance to the client and high differentiation potential for the lawyer. The more you commit to your clients, the more you provide what the client perceives to be over and above type of service. That's where we're at here, is back to that value equation. You're offering more benefits than what the client believes they're paying for. Number 5 is, as we've talked before, value, this vague notion. What does that mean? Well, in some part, it's a collection of the other ones. Understanding your client's business, you're having a client focus, and being committed is providing that value. You know, we want to get more for what we're paying. It's that V equals B minus C equation that becomes so important.
And there are at least three other drivers here within the top 5 that we practicing attorneys face every day. So let's take a look at each of these. First, with legal skills. You hope, certainly, that your legal skills have at least already been minimally known, or that your clients have been minimally educated about your legal skills before they've become your client. After all, they have to have some belief that you're a decent quality lawyer, or else they're not going to want to hire you to begin with. And how do you establish that? You establish those initial impressions, of course, through your marketing and advertising, as well as your general reputation throughout the community. Were they referred to you by another lawyer, by a friend, a former client of yours? All of those are factors in establishing your reputation for your legal skills. And then, of course, you have to follow through. These are continually reinforced by your actions and the services that you provide to your clients. And number 3, the quality of your products. In other words, you've got to make sure that the products that you are providing and marketing and advertising for are ones that you can perform at a very high level. In other words, if you're in a general law firm practice, but you don't really know or understand the area of, say, wills and trusts, you don't want to take on or advertise that you do wills and trusts if that's not an area you're terribly familiar with or at which you can provide a high-quality product. So you just need to be very cognizant of that. And then with number 4, keeping the clients informed. This is something that you're going to have to work on to continually reinforce the positive impressions of your legal skills. And you enhance that by maintaining quality communication with your clients. This is to be compared or contrasted with the quantity of communication. Just because you communicate with your client on a daily or weekly basis doesn't necessarily mean you're providing them with quality information or that you're having quality communication. You want to emphasize quality over quantity here. Not that quantity doesn't have some impact. If you have quality conversations with your clients, but you only talk to them once every 6 months, they're not going to have a very high opinion of you being able to keep them well informed about their case. You also have to correctly assess your client's sophistication related to your legal affairs. Just like with any other audience, you want to make sure that you're communicating your message appropriately. If your audience is a criminal defendant client base, and many of those criminal defendants have the equivalent of a high school or less education, you want to make sure that you're careful in your communications with them, that you don't talk over their heads. And at the same time, if you have clients who are more sophisticated, you don't want to talk down to them either. You want to make sure you're having appropriate types of communications with them and keeping them well informed about the progress of their case. Now, we believe it's also important that in these other 5 areas of the top drivers, client focus, understanding the client's business matter, dealing with unexpected changes and handling problems, as well as meeting the core scope, are very important. In fact, these are kind of the basics. This is what we call the price of admission, or at least what this particular group calls the price of admission. If you don't have these basic skills, the chances of you actually being hired for the representation of the particular client is extraordinarily low.
Once we have a sense of the client's expectations and what they believe the right attributes are for client service, there is one other consideration for you just to sort of keep in the back of your gray matter. About 30 years ago, a Japanese professor stumbled upon a remarkable phenomenon within the world of customer satisfaction. It's the idea that there are certain elements, as BTI says, that are price of admission, that are basic, and that get you no brownie points with your customers, but in fact helps you lose satisfaction. And that first area is what is noted by the green arrow called a basic. These are the basic expectations, the minimum expectation that a client would have for you. So for example, parking. You know, if you've set up an appointment with a client at your office, how do they actually get to your facility? Where do they park, or what's the public transportation? It's not so much providing them directions, but when they get there, what's that experience? You're not going to win any brownie points for having a really cool parking garage or parking lot or even parking space, but you will lose a lot of points if you don't have that basic service. Second, there are these performance characteristics. The better you execute, the more satisfied the clients are. So for example, keep this theme of a client visiting you. Your reception area. Everyone sort of expects they're going to be greeted and there's going to be a reception area. Doctors and dentists and accountants and all kinds of places have set this expectation of us as culturally in the U.S. society. So the better you make that, the happier they're going to be, and conversely, the less attention you put to that, the less satisfied they will be. And then finally, excellent or attractive. What are these things that will excite and go, wow? You notice the red line never falls into the low satisfaction level, because it's impossible for folks to be unsatisfied with these wows. So for example, Starbucks coffee. You know, if you decide that you're going to take that coffee beverage area up a notch and not only provide something but go that extra mile, and so the bottom of the red arrow just may be one, you know, Starbucks traditional blend, and then you could offer 5 different blends, or maybe you install a Keurig system and there's 25 different cups available. That just makes people a little more excited along the way. That is, just as we talk about those attributes, realize there are 3 areas that you have to pay attention to, and each has a different distinction. So you can spend less attention on the wow and more attention on the basics, and after a couple years in practice, then perhaps you can start shifting your attention a little higher. The reality is, looking at that gray line, time, over time, all of these sink. So even the excitable factors are going to sort of become commonplace, and they're going to fall over time into almost an expectation. So rather than wowing me, now I've come to expect that wow. So you're not getting extra brownie points for it if I come back a year from now and you still have the same 2 or 12 different coffee items. So what you always have to be thinking about, what's next. Let's call that the Steve Jobs effect. Sort of playing along that theme of Steve Jobs and what Apple has done in its marketplace, both for computers and smartphones, there has become a level of trust that there's going to be a coolness factor to their products, and especially the hours-long lines for iPhone releases. There's going to be a payoff. There's going to be a value. You're trusting that there's going to be something worth standing in line for, worth being the first in line for. That's a big factor in certainly product-oriented markets, but even more importantly, what I'll call invisible markets. We don't have a tangible product we're giving folks. Maybe they have a contract. Maybe they'll have a binder with their estate. But by and large, the service isn't the piece of paper. The service is you and your knowledge and ultimately your relationship. And so that's where trust enters the picture. Clients need to trust you to hire you and to retain you and to pay you. So often when we have collection issues, it's because the clients didn't think the lawyers gave the proper value. They didn't trust what happened. One of the legal industry's great thinkers, David Maister, I encourage you to look him up and find a lot of his materials. He wrote a specific book called The Trusted Advisor and outlines 5 stages that Joel's going to briefly discuss.
Really, all of this is still going to come down to the key theme, I suppose, of our presentation, and that is it's all about communication. As Maister talks about engagement, really, you need to talk about what you are doing to take the lead in engaging those clients, to seek out their pertinent information and ideas. Good client relations requires you as the attorney to take an active role in listening. This will help you to better understand your client's needs, their goals for the representation, and what their expectations are from their attorneys, as well as their motivations, what's driving them or what's driving their legal needs. Good client relations require that you establish the framework for attorney-client relationships and help your client set reasonable expectations and attainable results. Good client relations requires that you help your client see just what you can do for them and how your services may shape or change their business or their specific goals of the representation. And finally, a good client relations requires that you commit, not just in words, but also to follow up with specific actions to help your client succeed in attaining and or exceeding their goals and expectations.
I want to leave you with two quick quotes here as we're coming to the end of our presentation from Discovering the Soul of Service. What is exceeding client expectations today will only be meeting them tomorrow. A nice way of Kano's model showing that it all sort of becomes commonplace, so we always need to stay on our toes. And from the Rainmaker's Toolkit, satisfaction surveys show that between 60 and 80% of all lost customers report they are satisfied prior to defection. There's this big article 20 years ago maybe in the Harvard Business Review about how completely satisfied is the right benchmark when you're working with clients and not just merely satisfied, and this helps illustrate that in the legal industry. We need to know that our clients are really pleased with us, and the best way to do that is client feedback.
So then that talk brings us back to a discussion of client feedback and how do we maintain our client satisfaction? Well, one thing we can do is ask for their feedback. You can do this directly in one-to-one personal conversations with them, but in reality, this should come from multiple types of different forms. You need to continue to be a good listener throughout your representation of a client. This in and of itself will help provide you with some feedback. But truly, most clients are going to be intimidated by that one-to-one contact, and they're not always going to be willing to come right out and tell you what they think about you. Many times you have to dig deeper or drill down. This is when client satisfaction surveys can become a great tool. LexisNexis offers this service to their member attorneys, and I use it to gain feedback from my clients that may otherwise keep this information to themselves. If we as attorneys hope to improve our practice and client relations, we must allow for honest evaluation and feedback from our clients. If you're doing a good job of listening to your clients and maintaining good communications, your clients will reward you with further business from them, referrals for other potential clients, and perhaps even a client distinction award, which is given out by LexisNexis based upon your clients and the results of surveys that they send out on your behalf. So now here at the end, we want to also provide you with a bit of a bonus for the webinar, and we thought that it might be helpful to provide you with a checklist for those of you who are thinking about or have just recently started out in your own small or solo practice. I went through this process myself back in 2011, and some of these lessons I had to learn the hard way. First and foremost, my best advice is to maintain and obtain adequate professional liability insurance. Make sure that your insurance covers all of the different practice areas that you are intending to practice in, and that you limit your practice only to those areas that are covered by your specific professional liability insurance coverage. 2, make sure that you prepare a business plan in advance. And as a part of that, don't forget to include considerations of the type of business you're going to form, an LLC, LLP, PC, sole proprietorship, etc. And also don't forget to register with the necessary and required state and local government offices. If you have to register your business with your Secretary of State's office or other state agency, or with local agencies, you're going to need to make sure to do that. 3, prepare a realistic budget. 4, invest in cost-controlled yet effective marketing. Clients need to be able to find out more about you, who you are, and that you've opened your doors. Start your networking long before you start out on your own. This doesn't always have to be done in a very upfront sort of way, particularly if you're coming from another firm or other type of private practice, but just maintaining your networking contacts. But then once you do open your door, make a splash, hold an open house, invite everyone you've ever met to the open house. Incorporate your opening with your networking and marketing plans. Don't forget not to overlook your infrastructure, your office space, your parking, your furniture, hardware and software, internet, telephone lines, fax machines, printers, etc. You need to make sure you're taking those into account. Don't forget to beg and borrow as many legal forms and templates as you possibly can. Reach out to your contacts, see number 5 above, your networking sources. Get this information. 9, make sure to ask questions and seek advice. Many other attorneys have done this long before you have, and you would be shocked, I know I was, at how many people are out there really willing to help. And finally, be prepared for the first year or two to be some pretty lean times, realistically, especially if you're going into solo practice. The profits will eventually come, but you have to be patient and you have to be prepared to weather that storm. At this point, I think we're going to turn to answering some of the questions that have been posed to us online.
So the first one comes from Brian. He says, you mentioned flexibility. Are there benefits or problems with changing your hourly rate depending on the type of case, your experience in that area, and what you feel the client can pay? Well, from my standpoint, Brian, absolutely there are benefits for changing your hourly rate depending upon the type of case. There's value in various types of areas. You have certain expertise. I would think Joel would charge more for, say, educational law than he would for, say, divorce. And because of his awards with MAD and DUI, I would think that might be his upper range because people know him for that reputation. The only problems that I can think of from my standpoint is that, you know, the ABA says you have to be reasonable in your fees. And so ethically, could a client who was unhappy, and that goes back to satisfaction and keeping clients happy, you know, could they make a case against you? But I'm not so worried about that. Joel?
Well, and Patrick, let me chime in here too. I agree that you want to be, and it's very beneficial to be flexible in your hourly rates. But if you have a client, for example, that has hired you, let's say, for a DUI case, and then later comes back and hires you for a divorce case, and your hourly fees are substantially different, or your flat fees are substantially different, you're going to have to do a lot of explaining to that client as to why those fees are at different levels. So you just want to keep that in mind to make sure that you don't end up with that complaint to the bar or the disciplinary commission in your particular state.
It's all about communication. Joel, any experience in that area?
Thankfully, knock on wood, I haven't had any complaints from the Bar Association, but I have had clients that have hired me for multiple types of cases, and I've had to explain to them why I've had differences in my fees. However, I will also say that knowing that in advance, obviously you know who your clients are and what they've paid you in the past, I try to keep those fees as close to one another as I can, even if that means giving them a pretty significant discount on the second case, just to keep them as a satisfied client.
Tamika asks, once the fee is set and the work is done, how do you structure terms or protect yourself to prevent no or slow pay once the work is done and the case is over, but your fee is not paid in full?
Well, I can jump in and answer that one. First, for most of your cases, if you're doing an hourly fee basis or if you're doing a flat fee, you want to try to get your fees paid up front. Now, with flat fees, that's pretty easy. You tell your client what your flat fee is. You get it up front before you start doing the work, and you don't start doing work until the fee is paid. I think that's a pretty straightforward way of doing it. With regard to hourly fee cases, you may need to charge at what's called an advance fee. Some states or some jurisdictions call this a retainer fee as well, although I think that's a little bit of a misnomer. But you want to give the client a reasonable expectation of how much time the case is going to take or how many billable hours you're going to have in the case, and set that as your advance fee. And then let the client know that if you don't use up all of those hours, they're going to be entitled to a refund. But if you go over those hours before you get to that initial advance fee being exhausted, you're going to be sending them a letter asking them to replenish that advance fee or at least replenish it up to a certain amount until you think that the representation can be adequately concluded.
And unfortunately, that takes us to the end of the hour, so apologize to all the rest of you who had questions. Kathleen?
Thank you so much. On behalf of LexisNexis, I would like to thank both Patrick and Joel for an outstanding program today. If you have questions that did not get answered, please feel free to contact our speakers directly, and I'm sure they'd be happy to spend a moment with you answering anything that did not get covered today. We would encourage you to continue the conversation at our Twitter hashtag LexisSmallLaw, and would also encourage our attendees to complete today's evaluation, as it allows us to continue to bring you excellent programs that meet your needs. Thanks to everyone, and have a great day.